Good morning. Please be seated.
Good morning, my Lord. Good morning, Mr. President, and good morning, members of the board. My Lord, Mr. President, and members of the board, the prosecution will at this stage conduct their closing address. Mr. President and members of the board, all 26 accused persons standing before you this morning are serving members of the Republic of Sierra Leone Armed Forces. And we are here this morning, Mr. President and members of the board, to remind you of their participation in the incidents leading up to the 26th November 2023 and the unfortunate activities culminating from their participation of those incidents leading up to November 26, 2023. My Lord, Mr. President, and members of the board, it is our submission that the acts and conduct of all 27 accused persons before you violated the laws of this country, more particularly as provided in the acts creating the Republic of Sierra Leone Armed Forces, consisting of the guiding principles as to how a military personnel trained and enlisted should and must carry himself. My Lord, Mr. President, and members of the board, you could recall that the states in January preferred charges against 27 serving members of the Republic of Sierra Leone Armed Forces. And having conducted the commander's investigation, it was indeed recommended by their various commanders that they should all stand trial before this court-martial. And subsequently, my Lord, Mr. President, and members of the board, they all 27 were charged. And during the course of these proceedings, when the charges were put to them, Mr. President and members of the board, you could recall that the first accused had pleaded guilty to some of those counts. They also pleaded not guilty to some of the offenses charged in the counts in the charge sheets, Mr. President and members of the board. It was based on his guilty plea that the state graciously decided to drop the remaining counts, and this court-martial convicted that first accused, and he was accordingly sentenced. And Mr. President, members of the board, as it were, when he pleaded guilty and subsequently convicted, we are now left with the 26 accused persons before you, and they stand charged with 39 counts of committing a civil offense, 7 counts of mutiny, 7 counts of aiding the enemy, 24 counts of communicating with the enemy, 2 counts of stealing of public or service property, 2 counts of fraudulent misapplication of public or service property, 2 counts of receiving public or service property, 1 count of retaining public or service property, 1 count of willful damage of public or service property, and 1 count of conduct to the prejudice of military discipline and good order, all subject to provisions in the Armed Forces of the Republic of Sierra Leone Act of 1961 as amended. Mr. President and members of the board, you could recall that after the state dropped the remaining charges against the first accused who pleaded guilty, we had proceeded to give this court evidence relating to the first accused, which by his admission informed this court as to how plans were made and eventually executed, leading to the incident of November 26. That, among others, Mr. President and members of the board, the state will this morning remind this honorable court-martial as to not just what the first convicted accused did, but what he did in concert with his co-accused standing trial before you this morning. And to that end, my Lord, Mr. President and members of the board, the case against the remaining 26 accused persons before you is that they've all acted jointly and or separately. Jointly, I say, amongst themselves, the first convicted accused and others that are not before you. Separately, I mean as individuals. To engage in the acts alleged by the state against them, which the state believes amounted to serious violations of their guiding principles. My Lord, Mr. President and members of the board, at this stage I must hastily say the state has successfully led evidence beyond reasonable doubt with regards each and every allegation contained in the charge sheet before this court-martial against each and every of the accused persons before you, to warrant the convictions. Before going further, Mr. President and members of the board, I must say, at this stage of the trial, this court-martial must be reminded that it is the duty of the states to prove the guilt of the accused persons before you beyond reasonable doubt. And Mr. President and members of the board, beyond reasonable doubt would not mean beyond every shadow of a doubt, but rather you, Mr. President, and members of your board must be very sure that the accused did what the state is alleging. And how can you arrive at that conclusion, Mr. President and members of the board? It is not out of inference or things stated outside this courtroom, but what you heard, what you saw, and what you might be reading when you return for your deliberations. Again, what you might have seen or what you might have heard inside this court must be from that witness stand or from the dock where some of the accused testified before you. Further exhibits were tendered, screened. Those are the things that should guide you in arriving at your conclusion as to whether the state has proved the guilt of the accused beyond reasonable doubt. Mr. President and members of the board, the flip side would be if the state has not been able to establish that the accused did what is alleged, it is your duty to return, deliberate, and come back and return a verdict of not guilty. That is your responsibility, Mr. President and members of the board. Having listened to the evidence, having reviewed what is before you, if you are not sure that the accused did what is alleged, humbly crave your indulgence to go deliberate and return not guilty verdict so they can go home. However, Mr. President and members of the board, if you are sure, having listened to the witnesses that testified before you, having gone through all of the exhibits tendered in this court, you are of the opinion that the accused did what is alleged, it is your honorable duty to go, deliberate, and return a verdict of guilty. Mr. President and members of the board, with regards to your responsibility as to how you arrive at the conclusion that the state has established or proved the guilt of the accused beyond reasonable doubt, it is the duty of the state to have established during the course of this court-martial, which started on the 8th of January, each and every element of all of the offenses charged in the charge sheet that is presently before you. Mr. President and members of the board, again with respect, I'll remind you, we have successfully led evidence to show that the convicted first accused had connived with some of the accused persons and others who are not before you to unlawfully take arms and ammunition that was under the control of that first convicted accused while he was serving as the officer in charge of the Fudea Forward Patrol Base in Cambia. And those arms and ammunitions were unlawfully used by him and his co-accused to carry out series of attacks, which included the Cockerel Barracks, the Joint Logistics Unit, the Pademba Road Correctional Centers, among others. By engaging those conducts, Mr. President and members of the board, military personnel were killed, police officers were killed, civilians were brutally killed. As part of the plans, the first accused told you that he had facilitated the movement of some of the accused persons and others that are not before you to a village to visit a herbalist where they were given charms, believing they will be immune from gunshots. And it was after that mission that the first, fourth, and fifth accused persons later devised their plans as to how they can get arms and ammunition that were under the control of the convicted first accused, come down to Freetown, where some of the other co-accused were already waiting to execute the plans of the late night of 25th and early hours of 26th November 2023. My Lord, Mr. President and members of the board, the scheme was further having the 21st accused traveling from McKinney to Freetown, where he served in the military parlance in a position called Reki. Ordinary English will mean recognizance, a spy, awaiting the arrival of the co-accused, and also giving them information as to the whereabouts and movement of loyal forces of the Republic of Sierra Leone Armed Forces. Mr. President and members of the board, that scheme graduated into running to Wilberforce Barracks, not to stay in the billets, but to launch an attack on the arms store located at the Wilberforce Barracks, where the 17th accused person was the commander. Mr. President and members of the board, I will come to the duties and responsibility of a commander later on in the closing address. But at this stage, it is our submission that the 17th accused, being the commander, failed to prevent the attack to his arms dome. And in the midst of such failure, even if he were to tactically deny his responsibility, he failed to suppress the attack or to repel the enemies who had broken into a sacred building of the Republic of Sierra Leone Armed Forces. Mr. President and members of the board, all 26 accused persons abdicated their professional duty as military personnel. They had used violence to attack military installations, killing, as I've said, military personnel, police officers, and civilians. They systematically grew in number, Mr. President and members of the board, but they eventually met their match by loyal forces of the Republic of Sierra Leone Armed Forces. They were eventually repelled. Some of the accused persons, knowing that they have embarked on a failed coup mission, decided to return back to their various bases. It is our submission, my Lord, Mr. President, and members of the board, that the accused engage in acts of mutiny and further failed to prevent such conduct of mutiny, and the state has led sufficient evidence beyond reasonable doubt to support the allegations that are contained in the charge sheets before you. My Lord, Mr. President, and members of the board, will now turn to the charges against the accused persons. And I'll start with the offense of committing a civil offense as provided for in Section 72, subsection 1 of the Armed Forces of the Republic of Sierra Leone Act of 1961 as amended. And the act, that section, Mr. President and members of the board, provides, with your leave, my Lord, any person subject to military law under this act who commits a civil offense, whether in Sierra Leone or elsewhere, shall be guilty of an offense against this section. And by that section, Mr. President and members of the board, a civil offense means any act or omission punishable by the laws of Sierra Leone, or which, if committed in Sierra Leone, would be punished by any such law. With respect to the charge in that particular offense of committing a civil wrong, the state has charged the accused with the offense of conspiracy. And Mr. President and members of the board, conspiracy in law is an agreement between two or more people to do an unlawful act, or to do a lawful act, but you do it by an unlawful means. So the definition is such that if you are in agreement with at least between two people to do something that the law says no, you should not do, or to do something that the law says yes, this is what you can do, but then you do it through the back door, that is conspiracy. Mr. President and members of the board, as I've stated, agreements between two or more people can be conspiracy, especially if they have something they are working towards. I must state, with regards to the offense of conspiracy, Mr. President and members of the board, one need not be present for you to have conspired successfully with somebody else. So for example, two people can conspire, can be in agreements in Freetown, and the one will leave Freetown for Kabbalah to carry out the agreement. The one staying back in Freetown can be equally guilty as the one leaving to execute the plans in Kabbalah. Again, Mr. President and members of the board, we must submit that for an offense of conspiracy to hold, the states must prove that the parties to that agreement did something in furtherance of the agreement. And how that can be established, the mere agreement is in itself an offense. So you need not take step to actualize the agreement, but by agreeing, you are in fact guilty of the offense of conspiracy. Mr. President and members of the board, again, I must remind you that conspiracy involves mental elements, in that the states, in proving the agreement, which can be signified by your conduct, by communication, by sending messages, we must also prove the mental states of the person entering into the agreement. And that is the intention to carry out, firstly, either the unlawful acts or to carry out a lawful act by unlawful means. In zooming in on the definition already given, Mr. President and members of the board, the states or the doctrine can also rely on what is referred to as act and declaration principle. The definition has stated an agreement between at least two or more people. If one comes up and says, I agreed with my colleague to steal, that is the doctrine of act and declaration. They were both in agreement, and one person is now saying, we agreed to go and steal. With that principle, Mr. President and members of the board, coming from one of the conspirators, a court can convict for the offense of conspiracy. If the court believes the declaration of that particular conspirators. In summary, with regards that particular offense of committing civil wrong, Mr. President and members of the board, the state must prove that at least 2 or more people, and in this case we have 26, which falls perfectly well into the definition of having at least 2 or more people entering into an agreement. The state must prove that all 26 people were in all 27 who were initially before you were in fact in agreement between themselves and others that are not before you. Secondly, that at the time they entered into such agreements, they were serving members of the Republic of Sierra Leone Armed Forces. And based on the definition given and the criteria set out in section 72, we must prove that they have committed that particular civil offense, which in this case was conspiracy. Secondly, my Lord, Mr. President and members of the board, the state has charged the accused persons with the offense of mutiny. Mr. President and members of the board, the offense of mutiny is provided for in section 37(1)(a), 37(1)(b), and 37(2). And again, Mr. President and members of the board, to remind you of that provision, which you leave, my Lord, any person subject to military law under this act who takes part in a mutiny involving the use of violence or the threat of the use of violence, or having as its object or one of its objects the refusal or avoidance of any duty of service against or in connection with operations against the enemy, or the impeding of the performance of any such duty or service. And B, Mr. President, any person subject to military law under this act who incites any person subject to service law to take part in such a mutiny, whether actual or intended, shall, on conviction by court-martial, be liable. And 2, any person subject to military law under this act who, in a case not falling within subsection 1, takes part in a mutiny or incites any person subject to service law to take part in such a mutiny, whether actual or intended, shall, on conviction by a court-martial, be also liable. Mr. President and members of the board, with regards to the offense of mutiny, the states must prove the following elements. Firstly, the states must prove that a person charged with the offense of mutiny is subject to service law. And by service law, we mean he is a serving member of the Republic of Sierra Leone Armed Forces. The states must further prove that such person took part in the act of mutiny as stated under the various subsections. And that will include either to overthrow or to resist lawful authority in the Republic of Sierra Leone Armed Forces. Also, Mr. President and members of the board, the prosecution in establishing the offense of mutiny must prove that the accused either disobeyed such authority in such circumstances as to make the disobedience subversive of discipline or is the object of avoiding any duty or service against or in connection with the operations against the enemy. The prosecution again can prove, based on the section charge, that the accused impeded the performance of any duty or service in the armed forces of the Republic of Sierra Leone, or in any case cooperating therewith on any part of any of those forces. And finally, on the mutiny, Mr. President and members of the board, the prosecution must prove that the accused has as an object the refusal or avoidance of any duty of service against or in connection with operations against the enemy, or the impeding of performance of any such duty or service. Mr. President and members of the board, the prosecution has also charged the accused persons with the offense of failure to suppress mutiny. And that particular offense is provided for in section 38A and 38B. And which leave, my Lord, any person subject to military law under this act who, knowing that the mutiny is taking place or is intended, fails to use his utmost endeavors to suppress or prevent it, or fails to report without delay that the mutiny is taking place or is intended, can be convicted of the offense of failure to suppress. Mr. President and members of the board, with regard to the offense of one failing to suppress mutiny, the prosecution must prove the following four elements. Firstly, as with most of the offenses, we must prove that the accused is subject to service law, as stated, as serving members of the Republic of Sierra Leone Armed Forces. Secondly, the states must prove that the accused knew that a mutiny was intended or was taking place. And thirdly, the states must prove that the accused failed to use his best endeavor to suppress or to prevent the commission of that mutiny. We'll come to the difference between one using utmost or best endeavor to either suppress or to prevent. And fourthly, Mr. President and members of the board, the prosecution must prove that the accused failed to report without delay that the mutiny was taking place or was in fact intended. That is, before it was actually executed or carried out. Mr. President and members of the board, the state has also charged the accused persons with the offense of aiding the enemy, and that is provided for in section 30 subsection 1A and B. And with your leave, my Lord, any person subject to military law under this act who, with intent to assist the enemy, abandons or deliver up any place or post which it is his duty to defend, or induces any person to abandon or deliver up any place or post which it is that person's duty to defend. B, does any act calculated to imperil the success of operations of the armed forces of the Republic of Sierra Leone, of any forces cooperating therewith, or of any parts of any of those forces. Or C, furnishes the enemy with arms or ammunition or with supplies of any description. Mr. President and members of the board, with regards the offense of aiding the enemy, again, it is the duty of the states to establish 4 elements. We must prove that an accused before you, as at the time he committed the offense as alleged, was a serving member of our staff. And secondly, that the accused had an intention to assist an enemy or an enemy. Or proof that the accused abandoned or delivered up any place or post which it was his duty to defend. And fourthly, Mr. President and members of the board, the states must prove that the accused did an act culminated to jeopardize the success of the operations of what is usually referred to as loyal or friendly forces. Mr. President and members of the board, the offense of aiding the enemy also will require that the accused knowingly and without any lawful justification abandon or cause somebody else to abandon their post. We have also charged the offense of communicating with the enemy. And Mr. President and members of the board, the offense of communicating with the enemy is provided for in section 31, subsection 1, and subsection 2. With your leave, my Lord, Mr. President and members of the board, any person subject to military law under this act who with intent to assist the enemy communicates with or gives intelligence to the enemy shall, on conviction by court-martial, be liable. And 2, Mr. President and members of the board, any person subject to military law under this act who, without authority, communicates with or gives intelligence to the enemy shall be guilty of this offense of communicating with the enemy. And Mr. President and members of the board, again, I must remind you that the prosecution has the duty, if we are to succeed to successfully prosecute for the offense of communicating with the enemy, to establish the accused is a serving member of ISLAF, and 2, there must be evidence that the accused had an intention to assist the enemy, and thirdly, the prosecution must prove that that accused actually communicated with the enemy. Mr. President and members of the board, communication is a very broad term. We'll come to the nitty-gritties of what will amount to communication under the Act that all 26 accused were covered at the time they committed the offenses as alleged. Before going to those nitty-gritties, at this stage, I will remind Mr. President and members of the board that communication will include oral, and that can be verbal or written. We have also charged with the offenses of stealing, fraudulent misapplication, receiving, retaining, and willful damage of public or service property. Mr. President and members of the board, the offenses of stealing, fraudulent misapplication, receiving and retaining, or willful damage of service property are all contained under section 49A, B, or C. And with your leave, my lord, any person subject to military law under this act who steals or fraudulently misapplies any public or service property or is concerned in or connives at the stealing or fraudulent misapplication of any public or service property, or B, receives or retains any public or service property knowing or having reason to believe it to have been stolen or to have been fraudulently misapplied, or C, willfully damages or is concerned in the willful damage of such public or service property, commits an offense. Now, Mr. President and members of the board, with regards to those various modes of liabilities, the prosecution to successfully prosecute any of those offenses in section 49 must prove the following elements. Firstly, with all offenses under the Act, we must prove that an accused is a serving member. Secondly, we must prove that the accused stole public or service property, or what was stolen was in fact public or service property. Again, we must prove that the accused fraudulently misapplied. You can misapply public or service property, but there has to be proof that it was fraudulently done. We must prove that the accused received or had retained such property that was in fact fraudulently acquired in the first place. For willful damage, we must prove that firstly the property was damaged, and that will include permanent damage or temporary damage, or at the very least when it was removed from its original state. For example, you have a C box of ammunition and that box was removed. Even if the ammunition containing in that box was not applied, that's willful damage to the property because it has been tampered with from its original state and was now placed in a state to be used fraudulently. And finally, the offense of, we've charged with the offense of conduct to the prejudice of military discipline. And Mr. President and members of the board, that offense is contained in section 71 of the Act, and it shall leave, my Lord, it reads, any person subject to military law under this Act who is guilty of any conduct or neglect to the prejudice of good order and military discipline shall be guilty of an offense. Mr. President and members of the board, even though this offense is usually deemed within ISLAF as family murder, catch all, leave none, the state is still under the obligation to prove certain elements to succeed in establishing the family murder offense. Mr. President and members of the board, we must prove that the accused charged with conduct prejudicial is a serving personnel. We must prove that the conduct of the accused is in fact prejudicial to good order or military discipline. And how can that be established? We must show that military discipline, good order, have been negatively affected. Negatively. So, a serving personnel engaging in an act that will bring ISLAF into disrepute will amount to conduct that is prejudicial to his good order or discipline. Mr. President and members of the board, in addressing you on the first offense of committing civil wrong, we have submitted that we've charged the accused persons, all 26 of them, with the offense of conspiracy. And that particular section, section 72, which I earlier on submitted, provides for the states to charge any other offense that is punishable by any other law or that is deemed to be wrongdoing within Sierra Leone. In that vein, Mr. President and members of the board, the state charged the accused persons with the offense of murder, and stating what transpired leading to the incident of November 26, we have suggested that civilians were brutally murdered, military personnel were killed, police officers, correctional officers were all killed on the 26th of November 2023. And Mr. President and members of the board, was there any reason for those people to have lost their lives on the 26th? We do not consider those actions to be the divine will of God. We consider those actions to be the brutal and irresponsible acts of military personnel who were trained to defend their fellow personnel, to defend those police officers, to defend the correctional officers, and again, to defend an armless civilian. Mr. President and members of the board, unfortunately, that was not the case on the 26th. Regrettably, those who meant to have protected them turned their guns against them. They shot them in the head. They shot some in their stomach. They shot some from the body bag. They blasted RPG on one of them, resulting in even the pathologist to be able to reconfigure that individual for proper burial. Mr. President and members of the board, murder-in-law is defined as when a person unlawfully kills another person by doing something to that person with an intention to either kill the person or to cause the person serious injury, and that person dies within 1 year and 1 day following what was done to him. Mr. President and members of the board, death, of course, can occur through various means: poisoning someone, stabbing someone, strangulating someone, shooting at someone, or blasting RPG at someone. And it is not because RPG bomb was blasted on someone a court can convict for murder. The prosecution must prove that the person killed or the act leading to the death of that person was done unlawfully. We must prove what the accused did. We must prove that the accused participated, or what the accused did killed that person. We must prove that the accused had an intention either to have killed the person or to have caused that person serious injury. And we must prove that what the accused did led to the death of that person within 1 year and 1 day. This is very key, Mr. President and members of the board. If the evidence before you is that somebody was shot on the 1st of January 2023 and the person died on the 10th of March 2024, that is more than 365 days. You don't convict for murder. If, however, the person died between 1st January and 31st December, that is an offense of murder which you can consider. Also, Mr. President and members of the board, with regards to the offense of murder, the state needs not prove who actually fired the shots that killed someone. So you can have a platoon, you can have a unit, you can have 2 military personnel. Even if one in the platoon is carrying a weapon and all of them were moving towards that direction and the one pulled the trigger and killed someone, all of the members of that platoon can be held liable for the offense of murder. Mr. President and members of the board, when we started, we reminded you that it is the duty of the prosecution to prove the guilt of the accused persons beyond reasonable doubt. And that can only be done from the evidence before you. That was why, for good cause, Mr. President and members of the board, we led 37 witnesses before you, and we are relying on what they told you. We also tendered (188) exhibits. There were reasons for all of those, Mr. President and members of the board. Each of the exhibits tendered were tendered to establish a particular cause, which we'll show you in due course. Mr. President and members of the board, interestingly, some of the accused took the stand and testified on oath. Some called witnesses, And they also tendered exhibits, whilst others said, all right, we are going to rely on what the prosecution submitted. Others testified without taking the oath. They wanted to give their own explanation. And we'll come to show you by their own admission what they did between the period charge and the charge sheet before you. My Lord, Mr. President, and members of the board, the first accused was jointly charged with all 26 accused persons. That particular charge was read. What did he tell you? Mr. President and members of the board, the first accused told you, yes, I was in agreement with all 26 accused persons to carry out the acts contained in the charge sheet. The principle of law says if two people are charged, the act and declaration by one of them is good evidence to be considered by a competent court. Mr. President and members of the board, the first accused, who is now a convict, never pleaded guilty to some of the counts. He was never forced to have admitted before you that, yes, I was in agreement with all 26 accused persons to carry out what he told you in his statement. He said, all 26 accused persons knew of the plan for all 27 of them and others not before you to have committed mutiny. He knew the nature of the mutiny. Strangely, and for good cause, he told you, no, I did not kill anyone. He told you, I communicated with the enemy. He told you, as a military personnel, I'm sorry I failed to suppress this particular mutiny. He told you, as a military personnel, I did not act right. What I did was prejudicial to my good conduct as a military personnel. Mr. President and members of the board, this court-martial had additional responsibility to have refused the plea of the first convict, wanting to tell you that, yes, this is what I did. Having interrogated him, the court-martial came to the conclusion that we'll accept what you're saying. And it was accepted. Even though the state dropped some of the charges for which he pleaded not guilty, that act, by dropping those charges, had nothing to do with the other accused persons. For two reasons. Mr. President and members of the board, as the seats before you, they are all being tried jointly, but we have the duty to prove their guilt separately, except for the charge of conspiracy. Now, when there's a charge of conspiracy, Mr. President and members of the board, the courts can listen to each and every one of the conspirators as to what they can say against one another. In the absence of conspiracy, a co-accused cannot say anything about another co-accused. the court should not listen. But the law is, if they are charged with the offense of conspiracy, you must listen to what one is saying against the other. For good reason, Mr. President and members of the board. As stated, the offense of conspiracy is such that we are alleging that all 26 were in agreement to do something. And if one person of that agreement is saying, I did A, and the second accused or third accused did B, you must listen to them because that is the allegation that they all were in agreement. And Mr. President and members of the jury, in establishing the count, the first count in the charge sheet, the offense of committing a civil wrong, which is the offense of conspiracy, the prosecution, I first of all submit that we've led sufficient evidence against all 26 accused to show that they were in agreement to carry out unlawful acts or to carry out lawful acts. That is, it is correct, but then they did it in the wrong way. I will first of all refer Mr. President and members of the board.
No, I want the statement. Yes, Alaji.
To the statements of the first convict. That is exhibit HH 1 to 23.
I just want to read one side. Give me one side. I don't think so. Open page 46.
Mr. President and members of the board, in exhibit HH 1 to 23, particularly at page 3, Alaji, the first accused, told you, with your leave, my lord, I received a phone call from Amadou Koita, a former military personnel of the ISLAF, informing me that it has taken a long time trying to reach me. I asked him how he got my phone number, and he responded by giving me a name which I cannot now recall. He further told me that he was in London and that he was heading to his workplace, but promised to call me later. 2 months later, I received another phone call from Koita, and at this time, he asked me about my present deployment, which I responded as at Bamoluma in Cambia, as that was my present deployment at that time. He then asked me for my Orange Money number, as he was intending to send some money for me, and that I provided my Orange Money number. Later on in the day, I received the sum of 1 million old leones on my Orange Money number. And a few minutes later, Amadou Koita called and informed me that he was the sender of the same money. He, however, promised to send someone to me. Within the same period, I received a phone call from one Sergeant Kamara alias American. Now, Mr. President and members of the board, you will agree that we have a series of Sergeant Kamara within the ISLAF, knowing that Kamara family is very large. Mr. President and members of the board, the first accused was very emphatic in distinguishing the Camara to you. He told you the Camara was Sergeant Camara with an ISLAF number that matches the American that stands before you this morning. And it was that accused person, Mr. President and members of the board, the second accused, who is attached to the 5 Battalion Wilberforce. He's not just there, he's attached to the arms dome, the arms and ammunition store. They contacted him, and this is what he told you, Mr. President and members of the board. Whilst on the phone, Sergeant Camara asked me whether I know Amadou Koita, when I responded by saying yes. Sergeant Camara further told me that Amadou Koita wanted to confirm whether he knows me. It took some time without having conversation with Amadou Koita, but however, Sergeant Camara alias American was calling me and in the same instance raised concern that Amadou Koita was not picking his calls, for which I told him that it may have been as a result of his work schedule. Whilst at the FPB, I received a phone call from Sergeant Camara alias American, informing me that Amadou Koita was going to send money into my orange money. Now, Mr. President and members of the board, that information from the first convicts, insofar as the second accused was confirmed, the second bit was not just an ordinary gesture. The first accused in these statements further informed you that in fact he received that additional funds. He had coordinated with others for them also to be receiving additional funds, and that he puts together a team to visit one Passise. Certainly, I'm not from that offspring. Mr. President and members of the board, the first accused told you they visited Passise for a specific reason. In addition to what this said Koita and others have been doing to fortify themselves, the team they had put together also needed to fortify themselves. He told you they went there, have themselves fortified in readiness for the mission. Mr. President and members of the jury, what was that mission? That mission was to overthrow the legitimate government of the Republic of Sierra Leone. That mission was for them to abdicate their duty as military personnel. That mission was for them to be in communication with enemy. That mission was for them to refuse to repel any form of an attack. That mission was for them to conduct themselves in a way that will bring the ISLAF into disrepute. That mission was for them to brush anything in their way, which will mean if they were to kill everyone in Sierra Leone, they would have killed everyone in Sierra Leone. That was the mission they embarked on when they returned from that particular event. Mr. President and members of the board, do we believe the first accused when he said, I went with others to participate to fortify ourselves? Yes, the court can rely on his admission based on the Acts and Declaration principle because they've connived together, they were in agreement. We went further, Mr. President and members of the board. We presented Exhibit Abu. We presented Exhibit Abu showing the pictures of that convict and others visiting Pasise.
Major, can you add it?
And Mr. President and members of the board, unlike what we are told by one of the accused persons, that he went there because he had some issues with his wife and needed some form of cleansing. The first accused, who was genuine in his cause to admit it, gave him reason for visiting Pasise.
Let somebody go for light man for me. We'll call him.
Mr. President and members of the board,
Who are they? Our lights. Which one? We get the picture. Order. Call him. We'll get the pictures.
This? No.
In addition to Exhibit Abu, Mr. President and members of the board, we submitted the photos of that particular visit. The investigators were given precise explanation as to each of those pictures taken when they visited the herbalist. And Mr. President and members of the board, Staff Sergeant Alaji explained to us
check that out for you. Come. This can be first.
Mr. President, Mr. President and members of the board, from Exhibit Abu and Exhibit ABR 1 to 22, you could recall where extracted from the mobile phone of the sixth accused, who were giving an explanation as to what they were doing. Was that explanation coming up from the air? No. The first accused convict also told you in his statement, confirming what the sixth accused had told investigators with regards their movements. Mr. President and members of the board, this is the first accused convict, and he explained to you as to his meeting with this man he referred to as Supremo. Mr. President and members of the board, it was this man he referred to as Supremo who he said had contacted him whilst in London a couple of months ago. It was this man who he referred to as Supremo who later came and required them to fortify themselves to carry out the mission I spoke about. Mr. President and members of the board, the agreement, as we said, there need not be proof that all 27 accused persons met under the same roof, or met at the shrine of Passise, or met at Cochrane, or met at Cambia to enter into an agreement. There is no responsibility to the state to establish that, in fact, they all met in one room. The only responsibility we have with regards to the meeting of their minds is to show what each person did or said. And that was in furtherance of the grand plan they had. And that grand plan, Mr. President and members of the board, was clearly told to you by the first accused, by the sixth accused, by even the second accused. Mr. President and members of the board, it is our humble submission that with regards to the offense of conspiracy, we'll continue to rely on the Act and Declaration principle, and that you can listen to one accused as to what he says about another accused, and will submit that the prosecution has established or proved the case of conspiracy against all accused persons as charged. Mr. President and members of the board, counts 2 charging a particular form of mutiny. We have already stated the offense of mutiny as contained in the Act. And Mr. President and members of the board, the offense of mutiny
and the definition of mutiny
has a definition. Mr. President and members of the board, initially I've stated that it is the duty of the prosecution, firstly, to prove that an accused charged with the offense of mutiny is a serving member of ISLAF. Did we prove that? Mr. President and members of the board, all of the accused persons told you they are serving members of the ALC staff. In fact, some stood there and emphatically testified that I was enlisted, and they gave you the date. As at the 26th, I was deployed at, they gave you the location. None of them denied being serving members of ALC staff. In addition, all of the statements we tendered made by these accused persons during the investigations, they stated their ALC staff number, they stated their deployment, they did not deny that they are serving members of ALC staff. To falsify that piece of evidence, Mr. President and members of the board, we called our first witness. He's in charge of personnel activities. He told you from the stand that he's the custodian of records of serving members of ALC staff. Did he tell you that any of them are still members? Yes, Mr. President and members of the board. He told you that each of the accused persons were still serving members of the Republic of Sierra Leone Armed Forces. He told you that between 21st to 26th November, they were serving members of ALC staff. That piece of evidence remained uncontroverted. And I will respectfully submit that the prosecution has proved that part of the offense of mutiny. Secondly, Mr. President and members of the board, it was our duty to prove that they took part in a mutiny.
Now look for the definition. Sexuality.
Mr. President and members of the board, the definition of mutiny is contained in section 37, subsection 3. And with your leave, my lord, Mr. President, in this act, the expression mutiny means a combination between two or more persons subject to service law, or between persons, two at least, of whom are subject to service law, A, to overthrow or resist lawful authority in the armed forces of the Republic of Sierra Leone, or any forces cooperating therewith, or in any part of any of the said forces, or to disobey such authority in such circumstances as to make the disobedience subversive of discipline, or with the object of avoiding any duty or service against or in connection with the operations against the enemy. C, to impede the performance of any duty or service in the armed forces of the Republic of Sierra Leone, or in any forces cooperating therewith, or in any part of any of those forces. Now, Mr. President and members of the board, unlike the terminology treason, mutiny is stringent. Mutiny is concise. Mutiny has precision. Mutiny has what ALC is looking out for. Mr. President and members of the board, how can we arrive at the conclusion that all 26 accused persons did engage in an act of mutiny? Mr. President and members of the board, from the very definition, there has to be combination between two or more persons subject to service law. In effect, if you charge one person with the offense of mutiny, it is highly likely you will not succeed. Have we charged with one person? No. We've charged with at least two. That aspect of the definition, by charging all 26, was clearly met Mr. President and members of the board. Secondly, Mr. President and members of the board, I've already stated that they were subject to service law. They were not subjected just to the laws of Sierra Leone, but to service law, of which I cannot be subjected to. My conduct cannot amount to mutiny just because it is wrong. The conduct of a civilian cannot amount ordinarily to mutiny. There are other offenses. But for a serving personnel, Mr. President and members of the board, that conduct should be either to overthrow. So even if you don't overthrow, if you don't overthrow, you can still be convicted of mutiny. Interestingly, Mr. President and members of the board, if you resist lawful authority, Mr. President and members of the board, it is our submission that lawful authority within the ISLAF is clearly prescribed. And what will amount to authority in the eyes of the colors bloody civilians will be different from what will amount to authority in the eyes of a serving member. Taking weapon from the arms store without following due process. A civilian can casually transfer arms from one store to another if it's raining. A military personnel cannot. It is further strict. Lawful authority will mean doing what you are not supposed to do at the time it was done, even though it was right. Mr. President and members of the board, mutiny will also include when you disobey such lawful authority in situations or circumstances that will make the disobedience subversive of discipline. Now, Mr. President and members of the board, it is that definition that the states must satisfy. We must show the participation of each and every one of all 26 accused persons that they took part in the mutiny. We charge that they conspired, they're together, they committed mutiny jointly. First element established. We further submit that, what did they do? We must prove that they either overthrew or with regards to the authority. Was the refusal to obey the authority subversive? We say yes. And Mr. President and members of the board, we have stated that you should not act outside this court. There has to be evidence of all of the elements. Was there evidence of their participation in mutiny? We say yes. Again, Mr. President and members of the board, let's go to their conduct. I will come back to what the first accused, now convict, told you. But before that, I will look at what he told you and what the 26th accused person charged mutiny also told you or relied on. Mr. President and members of the board, we'll start with the second accused. Ibrahim Bundu Kamara Elias Amelkili.
A staff or a sergeant?
He's a sergeant attached. Will remind you of what he said when he left his house. He said, I had gunshots, I had blasts, I left my house, and I went towards the gunshots and where the blasts were coming from. Mr. President and members of the board, I know I am a civilian and I might be hesitant to run towards gunshots or blasts, but I also know that a military personnel is also human. It was the very accused persons, the co-accused, who told you, not Sergeant Kamara this time, that I had gunshots whilst at Cochrane. I took cover from view and from bullets. Even when asked, why did you go and check? He said, please sir, I know they go outside and shoot, I don't know what they did. Mr. President and members of the board, the second accused would want you to believe, as a quartermaster in charge of the arms store, he left his house whilst they were raining bullets, according to the 17th accused. They were shooting. Guns were being fired and bullets were raining as it rains in August. The second accused nonetheless wants you to believe, whilst bullets were raining, he left his house, he walked comfortably by my young mess, and he was captured. Mr. President and members of the board, eventually he said he was taken where the arms store were, and he was asked with others to carry arms and ammunition. That's besides the point, Mr. President and members of the board. Now, eventually, something happened in the morning. According to him, he was captured. There were superiors. He chose not to tell any of them that, I was captured, until he was arrested. He was only arrested when there was now evidence of his participation of the incident of 26 November of 2023. Mr. President and members of the board, he testified.
No, I want, yes. If you want to say something, what he said. You don't take
Mr. President and members of the board, I'll show you what he told you at exhibit AAV 1 to 17. AAV 1 to 17. More particularly, V. Yes, V.
I don't miss something. No, I missed it to it. Yes, to it and
go. Apologies. Mr. President and members of the board, at page 7, lines 7, this is what he told you when in fact he wanted to strenuously deny. It was not me that called Staff Sergeant Alhaji Kouma to inform him about the money, but rather he called me and told me that there was money to be shared for which he requested for my Orange Money number. I provided my Orange Money number given above, and the sum of 1,300,000 olios was sent to my phone by Staff Sergeant Alhaji Kouma. Now, Mr. President and members of the board, Staff Sergeant Alhaji Kouma explained as to why he shared that money not just among himself and the second accused, but among other people. He told you in his statement that that was money meant for the mission of 26th November 2026. Now, Mr. President and members of the board, the prosecution called a witness.
What's in our body name?
Alfred Methodist Cabo. Mr. President and members of the board, he was serving as a duty guard between the 25th and the 26th. Apart from him explaining to you how he had waived his superiors when they arrived in the Black Jeep Inn, he told you he saw the second accused who came from the barracks, went outside and was serving as lookouts. This was unlike what the second accused told you, that in fact he was captured on the way. Mr. President and members of the board, again, it was not regrettably done, but that evidence was never controverted, that Methodist did see the second accused coming out of the 5 battalion gates where he was serving as a guard. And it was that gate that was eventually used by the people whom they referred to as enemies or attackers, who eventually carted away with the arms and ammunition from the arms store. Mr. President and members of the board, in the statement, the second accused explained the people that arrived at the 5 battalion. He told you
line 16 to 19. No. line 20 to 20, yeah, AAV1. Next one, page 12, second Q&A. He admitted that he came back to the arms store because they were deceived by their bosses. The third, page 12. AAV or Q&A.
The evidence society the top wouldn't be tender. Lovely, but not clear itself.
Page 12, separate John.
Mr. President and members of the board, I'll take you to page 12 of the same exhibit. He was asked, we are putting it to you that you only return to the arms store because you are on the knowing that the coup plot had already failed. Therefore, you pretended that you have been arrested, thereby deceiving your bosses. What have you got to say? And this was what he told you. Yes, that is true, because we were deceived by our bosses. Further, Mr. President and members of the board, how were you deceived by your bosses? And this was what he said. I now wish to state that at the time Captain Senensi at the initial stage informed me that someone wants to talk to me on the phone, I spoke with Amadou Koita and to inform me that that time that he has an operation to overthrow the government of President Bio. He assured me that I should not be afraid and that there were very senior officers, including Lieutenant General P.K. Lavanu, Joint Force Commander Major General Dauda Alpha, Colonel P.S. Bokari. After this conversation with Koita, I called Staff Sergeant Kooma Alaji on the phone to confirm whether the information given to me by Koita was true, as I was aware that he was very close to Koita and Captain Senesi. Now, before going further on that, he had confirmed his knowledge as to the relationship between the first convict and that Koita. He has now confirmed to you about communicating with that Koita. He has now confirmed to you that he believed what Alaji was saying, and as a matter of fact, Alaji was his reference point. Mr. President and members of the board, again, he has strenuously denied that, I did not say that bit to the investigators. Before going further, I must address Mr. President and members of the board on that aspect. Whilst the statement was about to be tendered, he was given an opportunity whether the court should receive the statement or not. He said, through his counsel, no objection. And the law is that if it's now evidence before the courts, it should be considered. And the only fallback position will be as to the weight that can be given to such exhibit before a court. Has that been successfully challenged when he took the stand? We say no. Is there anything preventing this court-martial from relying on the content of what he told investigators when the issues were in fact very, very fresh in his mind? We say no. We respectfully submit that you treat what he told you in this statement with the necessary caution it deserves, and that the required weight be given to his explanation. Still on the element of the participation of the second accused, Mr. President and members of the board. He told you he was called by his superior, W22A. When asked throughout these proceedings about the whereabouts of W22A, he's not just a wall. They are still in search of him. He's on the run, Mr. President and members of the board. There's no evidence that he's dead, but there's evidence that he's on the run, which suggests he cannot be on the run for being a good soldier. He can only be on the run for being someone that is acting prejudicial to good order and discipline. And why would he call the second accused when the attack was made? The only answer to that, Mr. President and members of the board, was for the second accused to have joined him to execute why, in fact, W22A is not before you standing trial. Mr. President and members of the board, Mr. President and members of the board, just to bring to your attention what he said that was materially different from what he told you. At page 16 of his statement, he was asked, will we be correct to say that, contrary to what you told us in your previous statement, you voluntarily participated in carrying out the coup plot and not placed under any form of duress or coercion? And this was what he said: I volunteered to join them after they had convinced me, but was only placed under gunpoint at the time I was asked to load the magazine with ammunition. This is very key. Now, this was someone who said, I left my house, on my way, people were laying hands and I was captured. That's what he told you on oath. He told the investigators he joined the voluntarily, but every time he was placed on the gunpoint to carry arms and ammunition. We have two versions, and can it be relied upon, Mr. President and members of the board? He did not leave you with any option as to which version to believe. We gave you the version to be believed. We called witnesses who testified that they saw him, they saw what he did, and his conduct amounted to mutiny. We respectfully submit that the prosecution has established that element of the offense of mutiny. Thirdly, Mr. President and members of the board, it is very important, Mr. President and members of the board, on the issue of disobedience of authority. The first presumption is that soldiers are always under command. Soldiers are always under authority. It is when they want to change the status of your command, that's the time you are allowed to move from that command or authority. This is what is meant by that, Mr. President and members of the board. You are being deployed as a storeman. That is a level of command and authority you're operating under. But that will not mean you should open arms store for the sake or fun of it. For that general level to change, there has to be command to go and open. There has to be command for you to issue. Assuming without considering that he was captured and he was not the one who broke into the arms store, at the end of the day, he knew that the people who had carted away the arms and ammunition, for all or with all intents and purpose, did not disappear into thin air. They left in vehicles. Could he have done something more to legitimately go after those people? Yes, it was not armed. Armed stores were open in the morning and weapons and ammunition were distributed. He could not inform the senior personnel, according to him, who were now present. He could not tell them that, Captain Senensi was here, Captain Jallo was here, Poeta was here. They left with quantity of arms and ammunition. He did not tell them. For one reason, because he wanted to protect that particular status quo. He had the opportunity to have disclosed what went wrong and how he could have joined forces with now loyal forces and go after those people. He chose not to, on the understanding that we are under command. He cannot go by himself without being ordered. But, Mr. President and members of the board, had he informed the authority, would the reaction be different? Would the time to engage those enemies be time more than as it were? Would the untimely death of other personnel and civilians be prevented? We say yes, but for the conduct of the second accused in an act of mutiny. Now, before wrapping up on the second accused, Mr. President and members of the board, the offense of mutiny is what is referred to as an offense with specific intent. There has to be an intention for you to participate in the meeting. Mr. President and members of the board, what is in the mind or heart of a man, I'm not sure, can still be told by the look in his face. Mr. President and members of the board, it is that Herculean task we are left with to prove the element of intention. However, Mr. President and members of the board, it is an act which was swiftly addressed by the state. Intention in law, Mr. President and members of the board, is not capable of positive proof. So, for example, thefts. If you see someone taking something that does not belong to him and going away with it, you can see that, I saw him taking. But intention, it is difficult to say you mean it. But Mr. President and members of the board, the law is that intention can be inferred from the conduct of the person. That is, what the person said or what the person did at the time of committing that particular offense. For example, Mr. President and members of the board, if I put a weapon ready and shot in the head of a person and that person dies, I cannot say I'm not being meaner. The law would say, why would you put your gun ready? Why would you open fire into his head? That is intended to kill him. That's the same for mutiny. You cannot say you did not intend to participate in a mutiny just because, according to you, you were abducted. What did you do before and after and during the time of the abduction, assuming without conceding to his explanation? Mr. President and members of the board, witness told you he came voluntarily, he went into the streets, he looked up, he looked down, he came down, he went down to the armed store. Another witness told you, yes, I saw him at the arms store. They were packing arms and ammunition. By his own admission, he told you, I did not tell any of my superiors as to what transpired at the arms store. By his own explanation, he told you, I left my wife and children at home and I wanted to go to my brigade, my battalion headquarters. That's an honorary act to leave your children, to leave your family, to go to your brigade headquarters. However, such honored acts became dishonorable when you lied that you were captured on the way. When in fact your motive for leaving your wife and children at home was to assist an enemy. It became dishonorable when you cooperated with the enemy to take away arms and ammunition to cause mayhem. And by that conduct, you can infer that he intended to participate in the offense of mutiny. The third accused, Mr. President and members of the board. Staff Sergeant Albert Bassi Conte. Mr. President and members of the board, Staff Sergeant Alaji Bassi Conte was ordinarily deployed in Lunge. I think it's the 15th Battalion, Mr. President and members of the board. Can a deployed military personnel leave his deployment for any other place? I say yes, even though I'm a civilian. However, Mr. President and members of the board, you cannot just leave your deployment because you want to attend to, no matter how serious the issue is, there are procedures to leave your deployment. Regrettably, Mr. President and members of the board, the third accused choose not to follow those procedures. Was he negligent in his conduct? He was not just negligent. He had an intention to participate in the mutiny. As with the second accused, and as already stated, he's a serving member. He did not deny that fact. Together with others, he participated in mutiny. And what did he do, Mr. President and members of the board?
What are these? We're not denying picture. We're not denying picture. Where?
Now, Mr. President and members of the board, let's go to his explanation. When he had identified himself, and before you, he said, I visited one herbalist because I was having challenges with my wife. And from Exhibit Abu, Mr. President and members of the board, we have different explanations as to why he was seen at that particular place. Again, assuming without considering that, well, he went on his personal notes for charm to address the issue he had with his wife. Mr. President and members of the board, let us look at the explanation given by Alaji, the sixth accused, Smalley, and others. From Exhibit Abu, Mr. President and members of the board, we were fortunate not to have the third accused denied his face. However, he told you that from this photo, it's not too clear, I cannot tell. But we can tell. And with a picture. Now, go back one. Go back one. Go back one day. Yes. Now, Mr. President and members of the board, this was him. We can assume in one breath that it was a coincidence putting on these shots. Look for U126. Which one? U1. U126. Come on. Apologies, Mr. President.
See? U126. Major, what's up like major? What are you doing?
Now, Mr. President and members of the board, sorry for the break in transmission. Now, the coincidence is that he's still putting on the short pants, seated with others. And Mr. President and members of the board, what is interesting, when he testified, eventually he confirmed that yes, even though that person is not facing the camera, but he had gone to a certain herbalist. And we asked him whether he can recognize anyone else in this photo. Mr. President and members of the board, he said no, on oath. Now, the law is that when a witness testifies on oath, such testimony should be considered important. However, courts can discern whether the witness was being truthful or not. I'll take you to exhibit UU126 on page 5. Now at page 5, it was asked, at the time you went to perform the rituals at the village, did you meet other people there? Mr. President, this was what he said. Yes, I met people there. I was able to recognize Staff Sergeant Kalon of 15 Battalion Lungi. Now, Mr. President and members of the board, Staff Sergeant Kalon is the person seated by Bassi. Whilst in court, they cannot discern whether that was Staff Sergeant Kalon for obvious reasons. They had nevertheless confirmed going there and meeting him there. Mr. President and members of the board, what is the relevance of that? Was he trying to hide the truth now that he's in court? Or was he trying to be deceitful? It is for you to discern, Mr. President and members of the board. Now, Mr. President and members of the board, Staff Sergeant Albert Bassi told you he came to Freetown unauthorized. Unauthorized is my word. Unauthorized is the definition the ISLAF will give to a personnel leaving his deployment without a pass, as is required. Mr. President and members of the board, he told you on oath his brother promised to send him money. He also confirmed on oath, I know of Orange and Afrisel money. But he did not ask his brother to send by Orange and Afrisel money. He justified that then the way he said they give money, you know, can take, I know, get again. So he needed to leave. Mr. President and members of the board, this is a personnel who has served the military for more than 15 years. Was he willing to be dismissed for conduct prejudicial to come and collect monies that was below 500 leones, new notes? If he had served for only 5 years, he would not have willing to leave his job for 1,000 leones, which is 1 million old leones. Without judging him, Mr. President and members of the board, he chooses what to do. He chooses what should benefit him. If he wants the Orange money, he can come. But we've showed this court that there were other means for him to have received that money. He chose not to use the other means because he had an intention, because there was a grand plan. What was the intention? He needed to be in Freetown. What was the grand plan? He needed to be at Cochrane to ensure that the attacks are carried out. Mr. President and members of the board, he executed
Court rise. Let's stand our job for a few minutes. Yeah.